Hello, everyone, and welcome to Uncivil Law. And my friends, some people are not coping well with the news of Trump's pardons of the January 6 people. About 1,500 people have been pardoned. 14 people have had their sentence commuted, and some people are extremely unhappy. And some of those people are federal judges who want you to know that they're unhappy and are not going to prevent themselves from taking the opportunity to express that their unhappiness. So, my friends, the saltiness by many is very, very real. And the saltiness is coming from some of those who are federal judges who would like to let you know they are unhappy with you and they are grousing. They'd like to grouse on the record. They'd like to show their unhappiness and grouse on the record. So that is what we are doing. We bring ourselves to the case of United States of America versus Dominique Box, one of the January 6ers, whose case is being dismissed. Just by the way, of course, while 1,500 people were pardoned, anyone with pending cases had their case dismissed, which isn't quite the same thing. So while those pardons obviously are effective immediately, the dismissal of the case actually has to be entered and, adjudicated and stuff, which, might take a day or two. So of the 1,500 people were pardoned immediately, and then 450, had their cases dismissed, but that takes just a little bit of time. So this is one of those 450 stories. This is one of the 450 stories. Dominique. Let's learn a little bit more about Dominique from the Memorandum of Opinion and Order issued the January 22nd of 2025. The government charged defendant Dominique Box by indictment with 7 felony and misdemeanor counts for his conduct during the riot at the U.S. Capitol on January 6th. I do appreciate the judge restraining themselves from calling it an insurrection. I think riot is a much more accurate term. I have an entire series called the Capitol Riot series because I think it's a much more accurate term. And I do appreciate the judge restraining themselves and not calling it an insurrection. That's nice. In June of 2024, the court held a bench trial on those charges. At the bench trial, Box agreed under oath the written statement of stipulated facts was true and did actually occur. The court reviewed those facts with Box, and again under oath, Box agreed with or did not contest each individual stipulation. Dun, dun, dun. The government also presented substantial video evidence supporting the party's factual stipulations, and Box agreed that those videos depicted him. How exciting. After a period of delay occasioned by the Supreme Court's announcement of its case of Fisher, I do like how the federal judge says that. A delay occasioned by the Supreme Court. Yeah, I'm feeling like the judge may not necessarily agree with the Supreme Court either. I'm feeling a little bit of disdain in that direction. After the period of delay occasioned by the U.S. Supreme Court, who had the temerity to interfere with me, a federal judge. Who is the U.S. Supreme Court to interfere with me, a federal judge, says the federal judge. Of its opinion in Fisher versus United States, the court dismissed count 1 of the superseding indictment charging obstruction relating to destruction of papers, because, not so much on that, and proceed to render a verdict on the remaining counts. Based on the party's stipulations and the government exhibits, the court finds Box guilty beyond a reasonable doubt of civil disorder, entering and remaining a restricted building or grounds, disorderly and disruptive conduct in a restricted building, disorderly conduct in the Capitol building, and demonstrating or picketing in a Capitol building. Of all the cases for a federal judge to express their displeasure, this seems like an odd choice. This seems like an odd choice for a federal judge to say, I'm really, really unhappy. Because this is kind of a banal story, and we've covered this story many times, right? There are definitely people who assaulted police officers, and you could be upset about that. There are people who even stole things. You could be upset about that. There are people who destroyed windows or destroyed doors or broke things or otherwise created violence or destruction, right? So there are a lot of people that you could be salty at them being pardoned. But of all the people the judge wants to be salty at, he wants to be salty at a guy who apparently what he did was enter the building and was loud. This is a pardon that is completely unacceptable to the good people of the United States, says the federal judge. The person who had the temerity to enter the building and was loud should never ever be pardoned. They're so super duper guilty. Blah ha ha. I mean, I would, if you were inclined to do this as a federal judge, you would think you would save your ire for an occasion that would warrant, like, you know, a better example. This is in law, we would say this is a bad vehicle for this argument. This is a bad vehicle for this argument. Pick something that's a little bit more spicy than the guy who was walking around and was a little too loud while he was doing it. This is a bad vehicle for this argument, Judge. The court made specific factual findings supporting those verdicts. While Box stood outside the Capitol building on January 6th, he observed police officers using pepper spray against individuals to deter them from entering the grounds. Undeterred, Box followed the crowd as it pushed a small group of outnumbered police officers across the grounds, up the northwest staircase and into the facade of the Capitol itself. There, he paused to film as rioters shattered and climbed through windows on the ground of the Capitol. Again, maybe save your ire for a different case. Did Box himself push against the group of the Capitol officers? No. According to you, he followed the group, which isn't the same thing as being the group that pushed him. He followed the group. Did he shatter and climb through windows? No, he merely filmed it. That's, I mean, again, like, pick a different case, man. Aided by the rioters he had just watched break into the building, Box entered the Capitol through the Senate wing door at 2:14. He was among the first group of rioters to enter the building. Why are you wasting so much ink on this guy as opposed to, if you're going to write this, write it about one of the guys who did one of those bad things, not about Box. What did Box do? Box walked into the building and he filmed people who were breaking windows. Ooh, right? It's like, come on, man. Once inside, Box joined the crowd of rioters that overwhelmed officers and surged in the Capitol crypt. Did he overwhelm the officers? No, he was just happened to be there. Inside the crypt, an officer attempted to defuse the volatile situation by asking the crowd to calm down and avoid any more violence. Box walked up to the officer and shouted, "There's no talking. There's no fucking talking." Oh my God, Mr. Box used a swear word at the officer. Holy shit. Holy shit, he used a swear word. Oh my God. As the mob overran the officers in the crypt, Box, who was filming the scene, he was just filming it, proclaimed, "This is awesome." Well, Mr. Box thinks that what's happening is awesome as he's filming it somewhat passively, but this cannot stand. Box then briefly exited the Capitol before returning inside moments later. An officer immediately told him, "You don't want to be in here," and Box left. But a half hour later, Box was back inside, this time entering through the East Rotunda door. Box lingered around the door, which had been smashed and shattered, again, not by him. If he had smashed and shattered the door, that might be interesting, but he didn't. So you're just mentioning this as, like, I don't know. As officers pushed the crowd back outside and sealed the entrance. When rioters forced the door open again, I mean, again, not him. He didn't force the door open. Rioters did, not him. It doesn't say Box forced the door open. It says rioters forced the door open. So you're convicting Box by association. That's just fun. When rioters forced the door open again and pressed against the officers in the threshold, Box turned to the crowd and yelled, "We need more people." Box is scheduled to be sentenced for his 2 felony convictions and 4 misdemeanor convictions on February the 1st. Dun, dun, dun. On January 21st of 2025, the government moved to dismiss the indictment against Box with prejudice under the Federal Rule of Criminal Procedure 48A. As the reason for dismissal, the government cites a as yet unnumbered presidential proclamation. I don't know why the fact that it's numbered or not has anything to do with anything. The presidential pardon hasn't been assigned a number. Therefore, it's somehow less valid. I don't know. Assign your own number of choice. It's number 13. Why? What fucking difference does it make? The government cites an as yet unnumbered presidential proclamation titled Granting Pardons and Commutations of Sentence for Certain Offenses Relating to the Events at or Near the United States Capitol on January 6, 2021. That proclamation, in relevant part, directs the Attorney General to pursue dismissal with prejudice to the government of all pending indictments against individuals for conduct related to the events at or near the Capitol on January 6, 2021. Box has indicated his consent to the government's motion. Lord. By its term, Rule 48A allows the government with leave of court to dismiss an information or complaint. It does not explicitly grant either the government or the trial court the authority to vacate or set aside a plea of guilty, a jury verdict, or a court's finding of fact of law following a bench trial. The judge is so incredibly salty. He's so incredibly salty. See, for example, Smith versus State, or States versus United States versus Smith, noting that both the text of Rule 48 and its roots in common law doctrine of nolle prosecuale cast doubt on Rule 48's applicability of post-conviction without deciding whether Rule 48 can properly be used to vacate a final conviction. Well, if it's a final conviction, then he's pardoned. So, like, take your pick, right? I mean, this is the thing, right? If it is a final conviction, then he's pardoned, because the document you just quoted just now said that anyone convicted is pardoned. So take your pick. Which of these options do you like better, Judge? Do you like the fact that he has been pardoned or has been convicted, in which case this is a pardon? Or do you like the fact that he hasn't been convicted, in which case this is dismissed? Which of these options do you like best? Pick one. Anyone will be fine. Anyways, he's finally convicted, which incidentally, by the way, I don't think even is true in the federal system, because we've discussed this as we sort of were going through New York's law. While New York says that a conviction applies pre-sentence, or at least that's some of the case law does, as best as I was able to tell, along with my fellow lawyers when we looked into it, federal law does not. So federal law does not seem to determine something to be a conviction until sentencing, which means he wasn't finally convicted. Now, was he? At least as federal law is concerned, but, you know, let's ignore all that. That's fine. Questioning whether Rule 48 allows dismissal following conviction and unsuccessful direct appeal without resolving whether dismissal under Rule 48 was proper under this circumstance. However, the U.S. Court of Appeals for the D.C. Circuit has indicated in dicta, which if it's dicta, that means I don't have to follow it, but I'm going to anyway. So are we sure it's dicta? Lol. Has indicated in dicta, the government may seek dismissal of criminal charges under Rule 48, at least until a judgment becomes final on direct appeal. Concluding that trial courts have jurisdiction to entertain Rule 48's motions after sentencing and appeal. There is no precedent for applying Rule 48 to vacate a conviction after trial and appellate proceedings have ended. It follows that the government may also seek dismissal under Rule 48 before the trial court has sentenced the defendant. Well, one would think if you're allowed to dismiss it prior to the appeal being decided, then obviously this is prior to the appeal being decided now, isn't it? Consistent with that conclusion, at least 2 courts in this district have granted Rule 48 motions after trial, but before sentencing. Dun, dun, dun. Upon consideration of relevant authority, this court agrees that Rule 48 is a proper vehicle for dismissal of a criminal case with leave of court before sentencing. The court therefore must consider whether to grant its leave. Holy shit. Right? So this idea that you, as some of you may know, in the case law, right, that surrounds this proposition, the law does allow the court to technically review a dismissal, but it only allows the review of the dismissal in so much as it would prejudice the defendant. Like, for example, the idea that they're going to dismiss it, but only bring it back as part of a a campaign of harassment, basically, right? It's not a good faith dismissal. Right? It's not a good faith dismissal. This idea the prosecution could dismiss, but they're really secretly going to bring it back, and it's just part of a ping pong harassment thing. It's like in certain circumstances, they're like, no, you can't do that. But obviously, this is with prejudice, so not so much with the ping pong, and also the defendant consents. So, not so much. But the court must consider whether to grant its leave. See United States versus Ammerdown, noting the requirement of judicial leave in Rule 48 gives the court a role in following dismissals, even where the defendant concurs in dismissal. Yeah, I mean, we do have to protect the rights of the defendant, even in spite of themselves. So just because the defendant consents does not necessarily mean the court has to agree, because of course, the court does have to look out for the defendant, even in spite of themselves. So if it will serve to prejudice the defendant in a way that would benefit them, then the court can obviously step in and stop that bullshit from happening. But that isn't the present case. Also citing a case saying that under Rule 48 obviously vests some discretion with the court, not much, without deciding where discretion extends to cases in which defendant consists of dismissal. To inform the analysis, the court may require a statement of reasons and underlying factual basis for the motion to dismiss. Yeah. Here, the government's only stated reason for pursuing dismissal with prejudice is the president has ordered the attorney general to do so. The court does not discern, and neither party has identified any deficit in either the legal merits of or the factual basis of the government's case that would require dismissal. But recognizing that the executive branch has exclusive authority and absolute discretion to decide whether the prosecuted case, the court shall not require further explanation here. How nice of the court. How nice of the court to recognize that when they're dismissing with prejudice, that, not probably so much with the games and stuff. How very nice of the court to not require more. But we have more things to say, man. We have more things to say. Dismissal of the charges, pardons after convictions, and commutations of sentences will not change the truth of what happened on January 6, 2021. The judge is salty. What occurred that day is preserved for the future through thousands of contemporaneous videos, transcripts of trials, jury verdicts, and judicial opinions analyzing and recounting the evidence through a neutral lens. Those records are immutable and represent the truth no matter how the events of January 6th are described by those charged or their allies. Lol. What role law enforcement played that day and the heroism of each officer who responded also cannot be altered or ignored. Present that day were police officers from the U.S. Capitol Police and those that came to their aid when called, the D.C. Metropolitan Police Department, the Montgomery County Police Department, Prince George County Police Department, the Arlington County Police Department, and the Fairfax County Police Department. Grossly outnumbered, those law enforcement officers acted valiantly to protect members of Congress, their staff, the vice president and his family, the integrity of the Capitol grounds and the Capitol building, are a symbol of liberty and symbol of democratic rule throughout the world. For hours, those officers were aggressively confronted and violently assaulted. More than 140 officers were injured, not by Mr. Box, incidentally, so I'm not sure why we're discussing it. Mr. Box didn't do all these things. These were just things that were done by others, which, by the way, once again, is a bit of a problem, because why are we talking about it with respect to Mr. Box? Mr. Box didn't do any of those things. He wasn't accused of any of those things. He was accused of being there and being loud and filming stuff. That was what he was accused of. So I'm not 100% sure why we're talking about the officers who were assaulted, because Box didn't do the assaulting. So with respect to Box, who cares? Right? Again, this seems like this is a bad vehicle for this argument. Pick someone who actually assaulted a police officer, maybe. That might be a better vehicle for this argument. Holy shit. Others tragically passed away as a result of the events of the day. No, they didn't. No, we've been down this road. No, you know better, judge, bad judge. But law enforcement did not falter. Standing with bear spray streaming down their faces, those officers carried out their duty to protect. All of what I described has been recorded for posterity, ensuring that what transpired on January 6, 2021 can be judged accurately in the future. In the light of the foregoing, it is hereby ordered. The government's motion to dismiss is granted. The superseding indictment is dismissed with prejudice pursuant to Rule 48A. All scheduled proceedings and deadlines are vacated, and all pending motions are denied as moot. The clerk of the court is respectfully directed to disclose this case. So ordered, Colleen Coletti, U.S. District Judge, who was appointed by William Jefferson Clinton, incidentally, in case you care. So Colleen over here has some sharp words. Incidentally, I'm not sure for the right defendant. You know, of all the defendants to write these sharp words for, I'm not sure that this was the right choice. But this is what Judge Colleen Coletti. That's a lot of K sounds, by the way. Colleen Coletti. Oh my God! Right? That's a lot of K sounds. I'm not sure Colleen Coletti picked the best vehicle for this argument, but she's super salty, and she would really like you to know about it. And she'd also really like you to let you know that she's not happy. And also, the U.S. Supreme Court had the temerity to interfere with her judgment. She isn't really happy the U.S. Supreme Court had a judgment that caused one of the counts to be dismissed. That intervening Supreme Court, who are they to stand in the way of setting a federal judge? Holy shit. Well, my friends, I think that the saltiness is very likely to continue. I do not think by any means this is the only version of the saltiness we will see. I would imagine we will see other versions of the saltiness from other courts in DC and other judges in other cases. I'm sure they will figure out more exciting ways to express their saltiness. I am quite sure. But the process of releasing the people from prison and dismissing their cases continues. So we should see, hopefully, all these orders entered pretty quickly. So hopefully by the end of the week, all those will be entered, and hopefully shortly thereafter, all the people will be released from prison to the extent they have not already been. So it's exciting. All right, guys. Well, I'm going to go ahead and sign off. I've enjoyed the stream. I hope you've enjoyed the stream. This will be fun. At 6 p.m. or I think 5:55 technically my time, Central Time, in 5 hours, give or take, I'm releasing an edited video relating to the pardons. So you can check out that edited video. I think the edit worked out pretty well, and I think you'll enjoy it. So all the rest of it. Matthew Felty gives $2 to say, just think she happened to be stuck pre-sentencing. Yeah, exactly. She's not happy. So had she completed her sentencing, the guy would have just been pardoned outright. So I mean, whatever. So anyways, all the rest of it. I've been on Civil Law. Until later, my friends, I hope all's well. Cheers for now, my friends, and goodbye.